Judgment in the appeals have been on the application of New London College and West London Vocational Training College against the Secretary of State for the Home Department.
Lord Sumption will give the judgment.
The United Kingdom is a significant provider of educational services for an international market. These appeals are about the system for controlling the migration into the United Kingdom of people, mostly young, from outside the European Economic Area who wish to come here for study. The essential feature of the scheme is that the student must obtain an offer of a place on a qualifying course of study from a recognized institution called a licensed sponsor, which must have notified its offer to the immigration authorities by an electronic entry on its database known as a Confirmation of Acceptance for Studies, or CAS. Licensed sponsors are institutions which are licensed by the Home Secretary to sponsor international students for immigration control purposes. In order to obtain a license, they must satisfy her, or rather the UK border agency which performs the relevant functions on her behalf, that they meet certain published criteria regarding academic standards, the nature of the qualifications to which their courses lead, and so on. They must also undertake certain duties, for example, to assess properly the student's aptitude for the course and to monitor the student's attendance. Since April 2012, all licensed sponsors have been required to have what is called highly trusted sponsor status. This requires the sponsor to meet significantly more exacting criteria. A sponsor's license and the highly trusted sponsor status that now goes with it is of considerable financial value to any institution which accepts a significant proportion of non-EEA students on its courses, since it enables such an institution to assure the student that in the ordinary course he will obtain leave to enter or remain in the United Kingdom. These appeals arise out of applications for judicial review by two institutions which have failed to satisfy the UK Border Agency of their suitability to act as licensed sponsors. New London College was a licensed sponsor until December 2009, when its license was suspended on the ground that it had failed to comply with the conditions of the license. In July 2010, the license was revoked. The West London Vocational College, the other appellant, was also a licensed sponsor, but after April 2012, it needed to obtain highly trusted sponsor status in order to remain licensed. Its application for that status was rejected in August 2012. The effect of these decisions, which are challenged in these proceedings, is that students are in the ordinary course unable to obtain leave to enter or remain in the United Kingdom from the UK Border Agency in order to study at these two institutions. In the courts below, the two appellants put forward a number of grounds of complaint against the decisions affecting them, all of which were rejected either by the Administrative Court or by the Court of Appeal or by both. They have permission to appeal to this court on only one of these grounds, which raises an important issue of principle. The issue is this. Section 3.2 of the Immigration Act 1971 requires any rules regarding the practice to be followed in the administration of the Act for regulating the entry into or stay of people in the United Kingdom to be laid before Parliament. The rules are then subject to parliamentary approval under the negative resolution procedure, which means that they will be effective unless a resolution annulling them is passed in both Houses of Parliament within a specified period of time. The scheme operated by the Home Office and the UK Border Agency for International Students is contained in two documents. The first is Part 6A of the Immigration Rules, which requires any migrant seeking to enter or remain in the United Kingdom for study to have a CAS from a licensed sponsor. The second document is the UK Border Agency's sponsor guidance, which sets out the criteria for licensing sponsors, their duties once they are licensed, and the circumstances in which the license may be suspended or revoked. The immigration rules have, of course, been laid before Parliament under Section 3.2 of the Act, but the sponsor guidance has not. The appellants say that the sponsor guidance should also have been laid before Parliament, and that in the absence of tacit parliamentary approval, the Home Secretary was not entitled to make the decisions that she did by reference to it. The Joint Council for the Welfare of Immigrants and the Migrants' Rights Network have intervened on the appeals in order to make a more radical submission, namely that there is in fact no power to operate a system of sponsor licenses at all, even if the rules regarding sponsor licensing are laid before Parliament. The Supreme Court unanimously rejects both arguments and reaffirms the decision of the Court of Appeal that the Secretary of State was entitled to revoke the licence of the New London College and to deny highly trusted sponsor status to the West London Vocational College. The reasons of the majority of the Court are given in a judgment prepared by me, with which 3 other members of the Court, Lord Hope, Lord Clark and Lord Reid, agree. They are in summary as follows. The requirement under Section 3.2 of the Immigration Act to lay rules before Parliament applies only to rules about the practice to be followed for regulating the entry or stay of migrants in the United Kingdom. That means only the rules which the migrant has to satisfy in order to obtain leave to enter or remain here. The immigration rules which have been laid before Parliament satisfy this requirement because they lay down that a migrant seeking to enter or remain in the United Kingdom for study must have a CAS from a licensed sponsor, and they clearly set out what he has to do in order to establish that he has got one. The sponsor guidance certainly contains rules, but they are rules to be satisfied by the sponsor and not by the migrant. The migrant seeking leave to enter or remain here is concerned with whether the college where he wants to study is licensed to sponsor him. But he is not concerned with how or why the college got its license, which is all that the sponsor guidance deals with. It follows, therefore, that the sponsor guidance and the rules for sponsors which it contains did not have to be laid before Parliament under Section 3.2. The Supreme Court next turns to deal with the more radical suggestion made by the interveners that if the rules for sponsors are not within Section 3.2 of the Act, then there is no power to have them at all. The basis of this argument is that earlier decisions of this Court held that the power of the Crown to control immigration is wholly statutory. What is said is that since there is no basis for operating a sponsorship scheme under Section 3.2, and no basis to be found in any other express provision of the Act, there is no basis at all. The Supreme Court considers that the Home Secretary's undoubted power to determine, subject to tacit parliamentary approval, how applications for leave to enter or remain are to be dealt with, must carry with it a power to perform a range of ancillary and incidental administrative functions which are not spelt out in terms in the Act. The Immigration Act does not lay down the method of immigration control to be used by the Home Secretary. It leaves that to her, subject to tacit parliamentary approval. It cannot have been Parliament's intention that she should be limited to those methods of immigration control that require no preparatory or ancillary administrative steps, but only the grant or refusal of leave to enter or remain in the United Kingdom. Since the Home Secretary is undoubtedly entitled to lay before Parliament rules requiring international students to have a CAS from a licensed sponsor, it must be implicit that she also has the power to take administrative measures for identifying which sponsors should be licensed and on what terms they should be allowed to remain licensed. This power would not extend, of course, to measures which were coercive or invaded the rights of others or conflicted with the general constraints on administrative action in public law. But the Home Secretary has not transgressed any of those limitations in operating the sponsor licensing scheme described in the sponsor guidance. The Supreme Court also deals with an additional argument that the sponsor licensing scheme constitutes an unlawful delegation of the assessment of the suitability of international students to the licensed sponsors. This contention fails because the immigration rules reserve a general power to the UK Border Agency to decide whether a migrant is genuinely entering for the purpose of study, and empowers them to examine for that purpose the material on which he obtained his place on the sponsoring institution's course. These appeals, like so many others, have reached the court over the past few years, illustrate how ill-adapted the structure of the Immigration Act 1971 is for dealing with the growing pressure of immigration and the increasing complexity of the procedures required to control it. The present appeals will be dismissed.
Court is now adjourned.